Ms. Bradford, thank you for the response that you filed.
You're welcome.
I appreciate that.
Yeah,
That's helpful.
thank you. Good, thank you. Thank you. I do see several folks in the lobby. Do you want me to admit them?
Yes,
Okay.
yes, I don't have the ability to do that. So.
Okay, I think somebody did. Okay.
Good, thank you. Well, let's give it a couple of more minutes before we begin, see if there's any more people are interested in participating. Okay, let us begin. Let's go on the record. My name is Max Shepard, Shepherd, like the guy in the field of sheep. I have been appointed by the secretary to be the hearing officer in this proceeding. This is in the matter of the application of Yucca Growth Infrastructures, LLC, for an air quality permit, number NSR 10883, AQB 26-57P.
I think this is all small cap.
Okay, and before we, and so this is, would convene this to discuss a scheduling order. I've had input from several of you. I appreciate that. But before we get into that, we do have a pending motion that has been filed by the New Mexico Environmental Law Center and the Center for Biological Diversity. The motion is an objection to the scheduling conference that we have scheduled for today. Ms. Bradford filed a response to that motion. I don't know if there's any other parties that want to either comment in support of the motion or in opposition to the motion. If so, I will hear that at this point.
Mr. Hearing Officer, this is Crispy Hill, Assistant General Counsel, New Mexico Environment Department. We oppose the motion. We would be happy to flesh out something more in writing. I don't want to take up too much space here with oral argumentation, but we do oppose the motion, and maybe we can get into that, more substantively as you see fit. But I would like to say, just as a kind of housekeeping matter, that I think there's members of the press and members of the public here. They're welcome to be here, of course, but this is not a public meeting, and I don't think it's an appropriate place to take questions or public comment. There's a place for that. This is not about suppressing comment, but this is really a procedural conference for the parties, and there will be and are places for members of the public and members of the press to to make inquiries. And so the department is asking that members of the public and members of the press do not speak during this conference.
Okay, I agree and will grant that because that is my intent in scheduling this meeting. Simply, it's sort of a procedural meeting. We need to get scheduling, pre-hearing scheduling done. And that's what this meeting is about, actually, is just getting pre-hearing scheduling complete so this whole process can move on. So, and Mr. Buhill, have you had a chance to review Jennifer Bradford's response to the motion objection to the scheduling conference? That was filed just this morning. I don't know if you've had a chance to review
No,
that.
no, I have not had a chance to look at that.
Okay. Do we have any other comment on this motion from anyone participating in this hearing?
Mr. Hearing Officer,
Okay.
This is Maslin Locke with the New Mexico Environmental Law Center. I guess I have two things. One is just a point of clarification. If you'd like me to explain any additional points in our objection. And then I do have a few comments just on YGI's response to that objection, if I'd be allowed to give them.
Well, yes. Have you had a chance? Oh, I'm getting feedback. Have you had a chance to review Ms. Bradford's response to your motion?
I have briefly, Mr. Hearing Officer.
Maybe it would be more appropriate to allow Ms. Bradford to to take her turn rather than giving Ms. Maslock a second bite at the apple. We could take turns. That would, I think, be more fair.
Well, I have read Ms. Bradford's response. I think it's pretty thorough. And at this point, I think what would be appropriate if Ms. Bradford is if there's anything else that you want to add to your response, that would be appropriate at this point. Otherwise, I think allowing Mr. Locke an opportunity to respond would also be appropriate. So that's where we are. So, Ms. Bradford, if there's anything else you want to add, please take this opportunity to do that.
I think my response lays out our points in detail. In general, I want to make sure that the right statutory requirements are being followed here. There are certain statutory deadlines for air permit proceedings, permit application hearings that they must follow. And the authority to make decisions in those matters is vested with the secretary. The secretary does have power to delegate some of his authority, but here in the delegation of authority, he delegated the procedural matters for this hearing to the hearing officer. The timeline that is set out to hold the hearing and have a permit decision includes the post-hearing procedures, which are laid out in the regulations. And so I think we need to adopt a schedule that accommodates the deadline that's been established under the Air Quality Control Act. Most provisions throughout the regulations, and I did a deep dive yesterday, focus on making sure that our time is not wasted, that we're moving expeditiously, and then we don't have cumulative and unnecessary argument and testimony. And so we are striving to meet that, and we have made proposals in the proposed scheduling order with those considerations in mind, also thinking about fairness. Thank you.
Okay. Ms. Locke, any response?
Thank you, Mr. Hearing Officer. I just want to note a few things about the response. First of all, it's flatly incorrect that you as the hearing officer do not have the authority to extend timeframes. That authority is found in 20.1.4 100E and F NMAC. I want to note that we don't object to your authority to have this conference. Our objection is to the fact that notice of this scheduling conference was not given. The fact that many of us are here is based purely on word of mouth that we found out this was happening in a very rushed time frame. And to Ms. Bradford's point about ensuring that no one's time is wasted, I think our point is that rushing this process to have a hearing in August will ultimately result in a waste of everyone's time and energy. There is no way that we can get everything done that we need to in a technically correct manner following the proposals that have been suggested by the applicant and the Environment Department. And then if I could, I'd like to pass it to New Energy Economy, because they were the ones that raised the issue of determining application completeness, which I know is also something that Ms. Bradford raised in their response, just to provide that opportunity if Ms. Nanasi wants to do that. If not, no pressure. I don't want to put you on the spot.
Okay, good. Well, having heard your response with Locke, and also having reviewed Ms. Bradford's response to your initial motion, I'm going to deny your motion, and we will continue on with this scheduling conference today. I'll deny the motion based upon the arguments in Ms. Bradford's response. So that brings us then to, I would like to have the parties, although you have all done an interim appearance, I would like to have at least your appearance on the record at this point before we proceed. I know that's going to take a couple of minutes, but nonetheless, I would like to have that to make a complete record. So if we could begin, and again, everyone's on probably a different position on everyone's computer, so it's not like I can say, okay, the person at the top row, but Mr. Villa, why don't you begin? And then each of you are kind of going to be responsible for figuring out and then doing an appearance at this point on this record.
This is Chris V. I'm sorry, I was dealing with, there are people making public comments in the chat. Louise, can you either shut the chat down or remove those individuals? Thank you. So I didn't hear your question. I apologize.
Well, all of that, I would like to have everyone who's participating at this point to enter their appearance on the record.
Oh, thank you. I'm Chris V. Hill, Assistant General Counsel, New Mexico Environment Department, and I'm here with co-counsel Brian Yardman Frank.
Good, thank you. Next. Someone, speak up.
I'm Jennifer Bradfute. I'm with the law firm Bradfute Sayer on behalf of Yucca Growth Infrastructure, LLC. And along with me, I have my associate attorney, David Kermsey.
Good, thank you.
Good morning, Mr. Shepard, hearing officer. My name is Marielle Nanasi. I'm with New Energy Economy.
Thank you.
Morning, Mr. Hearing Officer. My name is Colin Cox. I'm with the Center for Biological Diversity.
Thank you.
Good morning.
Good morning. Go ahead, Mr. Maxwell.
Good morning. My name is Nicholas Maxwell. I'm a pro se intervener from the Lee County area. Thank you.
Good.
Hi again, Mr. Hearing Officer. I'm Maslin Locke on behalf of two community members, Jose Saldana Jr. and Vivian Fuller, with the New Mexico Environmental Law Center.
Thank you.
Mr. Hearing Officer, hello? Mr.
Okay.
Hearing Officer, my name is Bruce Weatherby. I'm here pro se. I've been excluded from this process in the chat. I raised an objection to your exclusion of me because I happen to be a reporter. I believe that's treating me differently, and I want that to be on the record that I object to that.
It is on the record.
Thank you.
Mr. Shepard, I would also like to go on the record for the same thing. I've made my objection in the chat, and my name is Derek Pacheco, representing myself out of Doña Ana County. Thank you.
Good. Thank you.
Mr. Shepard, my name is Jennifer Beaver. I'm with Williams, Weiss, Pepple, and Ferguson, and I'm also counsel along with Jennifer Bradfute for Yucca Growth Infrastructure, LLC.
Thank you. Ms. Esperanza?
Hi, good morning, Mr. Shepard. My name is Esperanza Chaides. I'm here representing Youth United for Climate Crisis Action. I also object to my participation being limited today due to being a member of the public.
Okay.
Thank you.
Anyone else?
Good morning,
Hi.
Mr. Shepherd. My name is Ashley Proud, and I work for Healthy Climate New Mexico. Thank you.
Okay. Now, we have really just a few schedules that we have to address. The first one, of course, is when are we going to have the hearing in this case? There have been suggestions from NMED, corresponding suggestion from Ms. Bradford's group that the hearing commence on August 17th with the notice of intent to file technical evidence on August 3rd, rebuttal, a notice of intent, technical evidence on August 13th, and then the other date that needs to be set is the date to file motions, pre-trial motions, and also a reply to those motions. Those dates, I will say right off, correspond to dates that work with my calendar. I'm going to be gone for part of September, and if this were to be heard the first part of, the 17th of August, that would certainly work with me. The question is, of course, do the parties think they can be ready actually to present this case at this point? And that, of course, is both Yucca Industries and NMED to begin with. If both of those parties think they're going to be ready to present the case at this point, and then other parties who may intend to submit technical evidence or rebuttal technical evidence, how likely are you going to be able to meet these deadlines of beginning the hearing on August 17th?
NMED will be prepared.
Mr. Hearing Officer, the applicant will be prepared as well.
Okay. Other parties? Honestly, how prepared do you think you would be for these dates?
Hearing Officer Shepherd, this is Marielle Manassi, attorney for New Energy Economy, and I'd like to be heard on this matter, if I may.
Yes, go ahead.
So I would like to talk about the completeness of the application, Your Honor. New Energy Economy's position is that the application is not complete. And I believe that you have, and actually it's your duty to determine the application's completeness. I request before this proceeding advances further that you make an explicit determination on the record as to whether Yucca Growth Infrastructure's permit application is legally complete. This is a fundamental due process issue. Before the parties undertake extensive discovery, expert testimony, and a full evidentiary hearing, there must first be a determination that there is, in fact, a legally sufficient application before the department. If the application is facially deficient, proceeding to the merits would unnecessarily consume enormous public and private resources, only to discover later that the application never satisfied the threshold requirements for consideration. I usually practice in the before the Public Regulation Commission, so I'm most familiar with their procedural rules, but I understand that they're quite similar, actually, to the rules that govern the Air Board. The Public Regulations Commission's hearing examiners have confronted this precise procedural question before. Hearing examiners did not simply move forward on the merits when substantial questions arose concerning the sufficiency in those two cases that I'm most familiar with P&M's application. This just happened in the proposed Blackstone acquisition of P&M. Instead, they have halted.
This is a completely different.
Excuse me, I am speaking and you're interrupting.
No, hold on a second. We're not having a hearing. We're not having a hearing, and you're wrong on the law. It's okay. But
it's okay that you let me speak and you be quiet.
Well, wrap it up. Please wrap it up because you're wrong on the law.
I will
Please.
talk until the hearing officer, not you, determines differently. Please do not ever interrupt me again. I didn't interrupt you. You are being, you're trying to.
I'm being an advocate.
No, you are interrupting.
Excuse me. I'm not going to have this sort of outbreak. I will not have it. Okay?
Thank you.
I understand your point that you've made, Ms. Nanase, and Mr. Vigil, if you want to address that very quickly, please do at this
Sir,
point.
can I finish? Because I would like to make my record, and I think I have 3 points that are necessary for that.
How? All right, go ahead.
Thank you so much, sir. This type of orderly procedure is requested by New Energy Economy here. Our concern is not merely technical. The application before the department relies upon emissions estimates derived from 4 4-hour tests conducted on a single 65 kilowatt Bloom Energy server operating under ideal laboratory conditions. Those results are then extrapolated to a proposed facility consisting of 2,275 individual fuel cells, representing a project approximately 38,000 times larger than the tested unit. This is not substantial evidence. Our Supreme Court has repeatedly held that agency decisions must rest upon substantial evidence that is credible in light of the entire record and sufficient for a reasonable mind to accept as adequate to support the agency's conclusions. That, I can give you the site for that, is New Mexico Industrial Energy Consumers versus New Mexico Public Regulation Commission. Likewise, in Albuquerque Cab Company versus New Mexico Public Regulation Commission, it teaches that agency action becomes arbitrary and capricious when there is no rational connection between the facts found and the decision made, or when the agency fails to consider important aspects of the problem. Here, the department is being asked to approve emissions projections that have never been demonstrated under anything remotely resembling real-world operating conditions for a project of this magnitude. Equally important, the application.
I object. She's testifying. She's an attorney. She's offering testimony. This is not a hearing.
Thank you.
Excuse me, both of you. I understand where you're going, Ms. Nanase, and I have to agree that your argument at this point is not appropriate to this proceeding. At this proceeding, we're simply trying to set some schedules so that we can move on, and some of the issues that you've raised can then be litigated more thoroughly once we're there. But that's not what I'm sorry, that's not what we're doing today. Today, we are talking about scheduling to get to an initial hearing. And that's where we're going.
I understand, hearing officer. The problem is,
you have made your record.
But I haven't made my record.
Well, you've made the record that you're going to be allowed to be made at this point.
The problem is,
made the record. If you want to submit something addition in writing, you certainly can do that. But you have made the only record you're going to be able to make orally at this point at this hearing, and we're going to move on.
Okay, I'm asking Your Honor that these are threshold issues. I
understand what you're asking, and I'm saying that those are not the issues I'm deciding at this point. That's what I'm telling you. That's my ruling at this point. I'm not deciding these issues at this point. We're moving on, trying to get some schedules in place so we can move this whole case forward. You may not like it, but that's where I am on your arguments right now.
And is there a time
Okay.
that you will, yes, is there a time that you will make for threshold motions to be determined? That's the point of.
I'm sure. I'm sure there will be. I don't have that date at this point.
That's what I'm asking, Your Honor, is that.
I don't have that date. I do not have that date at this point.
I
do not
did
have that
put
date
those
at this
dates
point.
in our procedural order.
In the procedural order,
Yes, I suggested a draft procedural
I know,
schedule.
I saw that. I saw that in your draft of procedural order, and it was not something that I was going to incorporate into the order that I issued at the end of this hearing. I'm not going to set a date for making that determination at this point.
So we
Mr.
can just
Hearing
file
Officer,
motions.
Could we ask why?
I'm sorry.
Could we ask Mr. Hearing Officer why you aren't going to do that?
I'm just not prepared to do that at this point. I don't have enough information in front of me.
So if we.
Well, why is it being rushed so much then? Why not give yourself enough time to adequately look at all of this? This is a reasonable request in any governmental proceeding, whether it be quasi-judicial or before a legislative body or some administrative board.
I will tell you what my thoughts on this are. And they are really, I think that the citizens of Donna Ana County need to get a resolution of this issue, whatever it is, whether it's pro or go forward or stop. This is going to have a huge impact on their lives, either positively or negatively. I have no idea how that's going to turn out, but I think that they have the right to have this decided as quickly as possible. And if that puts some rush on moving forward here, that would be the reason that's the reason that I would move forward on this. Now, again, I have been appointed the hearing officer about a week ago, so I've come into this, a little late compared to you guys, but at this point, that's, I did not set the schedule initially, but I see some value in the schedule as it has been set. So that would be my response to that.
And Mr. Hearing Officer, if I may say, anyone who enters an appearance is free to file a motion anytime. Once you become a party, then you can file whatever motion you feel like, Mary Nell. So, if you have a substantive issue you want to raise, then you can file a motion and we can engage in motion practice and, sort of litigate the issue and get a decision made. You could do that today, tomorrow, pretty much any time. I think there's a time limit under the rules when you can present them. You probably can't present it, I need to look at the rules, but there's probably a time limit with regard to the hearing, but you definitely can file a motion and bring all these issues. There's no restriction on that. And you could do that today if you wanted.
So given that, Mr. Hearing Officer, that was why I was bringing this up, which is, do you want to set a schedule for dispositive motions? I think that that's like a regular procedural matter in all sorts of agency cases. And that's why I raised all of this, because if you read what the NMED has thus far stated, it's only been a preliminary decision, a preliminary determination of completeness. That's why I raised this whole issue.
Okay, fine. Do you have a response from the Environment Department or from representatives of Yucca Growth Industries.
Mr. Hearing,
Yeah, go ahead.
Mr. Hearing Examiner, if I may. So I do think that we should set pre-hearing motions deadlines, which were circulated in the proposed scheduling order. I think those pre-hearing, which should include dispositive motions, because dispositive motions, the sole purpose is to, answer legal questions, pure questions of law prior to the hearing. Completeness is a factual question. All the things that Ms. Nanasi just laid out are all items of evidence that would be presented at the hearing that need to be weighed by the ultimate decision maker and fact finder. And so, but I do think we should have some pre-hearing motion deadlines that run. Our proposal was on August 12th, although August 13th would be appropriate for motions, with responses on August 17th. I realize that's going to be a very tight timeline, but that happens normally over at the Oil Conservation Division and some of our other sister agencies that have hearings where they are trying to have matters heard within given timeframes, regulatory timeframes. And so I think it's entirely reasonable to set pre-hearing motions, including dispositive motions, prior to the start of the hearing. And I think the parties can accomplish that. Ms. Nanasi sounds like she's almost ready to file her motion as we sit here today, and she has a lot of her arguments thought out.
Right.
Yeah.
Yeah, well, thank you. Certainly, I'm sorry, Ms. Nanasi, I didn't quite articulate as well as I should. It was my intention to have a schedule for pre-hearing motions. My idea was that we should be filed about 30 days prior to the hearing date, and then a reply to any opposed motions 10 days after the motion has been filed. And that was, that was my intent, to include that in the scheduling order.
Thank you, Your Honor. Do you have any ideas about dates, or do you want discussion further about the hearing itself? I will just tell you that I found out about this. You found out about this 5 days ago. I found out about this 2 days ago. There's no way that we can have expert testimony on August 3rd and August 13th, which is basically 2 weeks from now. I mean, to have testimony written, I don't even have experts in mind yet. It's just too rushed. And so if you are going away in September, I would ask that at minimum that we set it for November. These are reasonable timeframes. I mean, we asked for after the legislative session but if you want to do it in October, I'm certainly available, and I could have experts ready to present technical testimony and technical rebuttal testimony. I think that a matter of this incredible public concern, like you've already stated, it's important to Doña Ana County, it's important to the state, given the tremendous carbon emissions that will be emitted from this facility, and many other issues. Not just those, not just emissions, but the health and welfare of the people of Doña Ana County and New Mexico. It's obviously gotten great public concern, and to rush it to have a hearing finished in 1 month is unnecessary and unreasonable. So I'm respectfully asking that it be continued to a more reasonable time frame.
Okay. Your objection is noted. Yeah, we'd also had some suggestions that the hearing not proceed until April of 2027, and that seems completely out of the realm of possibilities. At this point, I'm going to include in the order that I am going to enter that the hearing is going to be set for August 17th with the notice of intent to file technical evidence be August 3rd, rebuttal August 13th. Motions, all pretrial motions, dispositive to be filed 30 days before the hearing date.
That's in 2 days.
Pardon?
Mr. Hearing Officer, if I could, there are other people with their hands raised, other parties that have comments on the proposals. Would it be appropriate for us to share those thoughts before you commit to that decision?
Yes, go ahead.
Okay, thank you. I want to just mention that you mentioned that Doña Ana County has the right to have this decided as quickly as possible, but I want to note that the only two groups pushing this forward as quickly as possible are the Environment Department and Yucca Growth Infrastructures. Neither of them are residents of Doña Ana County. Folks that are here representing residents are asking for more time in order to prepare a highly technical case to make sure that the Environment Department meets its legal obligation to protect the public health and welfare of all of New Mexico residents. So while I can understand and fully respect that April might be too far of a deadline, I think there are many of us that intend to engage that simply cannot engage in August. I think there's possibility for, like Ms. Nanasi said, having something in October, having something in January before the start of the legislative session. This is an enormous issue that's going to have enormous consequences, and rushing this when every other party besides the Environment Department and the applicant are saying they do not have time to pull something meaningful together, and that rushing this is going to create significant due process issues, is an irresponsible decision. So we're asking for something other than August, additional time, because as Ms. Nanasi said, most of us found out about this 2 days ago. Nothing has even been noticed in Spanish for folks, and this is impacting a community that is primarily Spanish speaking. The hearing notice hasn't, or the hearing determination has not been published in Spanish. It was not published on the Environment Department's public access, like public notice webpage. And asking folks to just figure this out in such a rushed time frame is going to create more problems than it's going to solve by rushing this application through for some alleged economic benefit to the state of New Mexico. So with all due respect, I would strongly urge that we delay this at least a few months in order to ensure that everyone can actually meaningfully participate. And I think, I don't know if you can see everybody's hands, but the next hand up, I think, is Mr. Cox with Center for Biological Diversity.
Thank you, Ms. Locke. Yes, Mr. Hearing Officer, I would kind of echo all of Ms. Locke's objections to starting on August 17th. I mean, you asked earlier if the parties could be ready by then, could have our direct testimony ready in just over 2 weeks and rebuttal a week after that. And the answer is no, I could not have it ready. We proposed an April hearing because we're thinking we put it after the legislative session, and so we weren't briefing over the holidays. It doesn't have to be that far out. We could be ready by the fall. We could be ready in October or November. That would likely mean briefing over the holidays, but if that's what we want to do, we can do that. But an August 17th hearing is just, it's not workable, and it would be incredibly unfair to us and to all the others that are very interested in this application. I just want to note a couple of things. So as the hearing officer, you have the authority to set the schedule. And that schedule doesn't have to end in November. If we look at NMSA 72-2-7B3, if the schedule you set ends up going past a November decision, all the department has to just notify the applicant. That does not require determination or action by the secretary to extend the deadline. You have the authority to set a reasonable schedule that's fair to all the parties here. I also want to note that when we're talking about pre-hearing motions, so like after the filing, like some of those motions are motions in limine, right, to exclude evidence. Those motions we would file after rebuttal testimony, potentially, right? If a party files a rebuttal testimony another party objects to, we should have an opportunity to file a motion on that. And the Environment Department rules at NMAC 20.1.4.200D give 15-day response window and a 10-day reply window. So we need, we need probably 40 days or so after rebuttal testimony is due before the hearing can happen to allow appropriate time under the rules for motions practice, right? For pre-hearing motions practice in the rules. So I think those are kind of my main points. I just much prefer. I mean, we need a hearing date in October at the earliest. Potentially November would be better. But there's no way that I can be ready with a full case in 2 weeks for a hearing in 30 days. And then last point, thank you for your patience. The department has not put out its technical review of the permit. It hasn't published its analysis of the permit. It hasn't published a draft permit. Most of the documents that we would need an expert to review to have a proper hearing are not even available for my expert to review. An expert that I haven't even hired yet because this hearing determination was only made a few days ago. So we really need more time. We need the department to finish its analysis, to release the rest of the documents that would be part of this hearing. And we need adequate time. So I'm asking for a hearing in the fall. Thank you.
Mr. Hearing Examiner, if I may respond.
Yes, go ahead.
Yeah. I think the opponent's arguments, one, are examples of the fact that we do need some coordination requirements between the parties. There is one applicant and many different advocacy groups in opposition that are essentially raising many of the same types of arguments that could be united in order to create efficiency of time during the hearing, particularly when it comes to cross-examination, and we made some proposals in our scheduling order proposal. But one thing I did want to note is that many of the timelines are not actually being accurately represented when you look at the rule language, right? The notice of hearing needs to be submitted 30 days prior to the hearing. Likewise, the agency's proposed analysis of the application has a 30-day comment period. All of that is a time period that has been contemplated by the Environmental Improvement Board when they created rules for the hearing process. And so this 30-day time period was deemed proper, deemed sufficient, both by the Environmental Improvement Board and by the legislature. And when you look at when the legislature created the timelines for air permit submissions, they created a strict 90-day timeline with exceptions only in limited circumstances. And they used things like making sure that in the rules, the EIB used things for that expedition of process to make sure that these permit applications don't languish forever. There's not unnecessary or undue delay. And the discretion that the legislature gave, they actually appointed the timeline decision-making authority specifically to the cabinet secretary or the department director. And so then the secretary by the legislature the EIB decided can then delegate some of his authority. But here we have to look at that delegation of authority. And here there is no statutory authority for a hearing officer to extend that 90-day deadline. And so I really want to be cautious here that we are not creating an order that would create a legal violation of the Air Quality Control Act when there is a clear mandate from the legislature to move expeditiously. And the legislature, in their wisdom, created that, regardless of what any advocate here wants to advocate for or against. And so those are the guardrails that we must operate within. And then looking at the EIB rules, they do not talk about delay. They do not talk a lot about prolonging procedure. They create 30-day timelines again and again and again. And if you look at hearings in front of a lot of our sister agencies, there's a very similar 30-day clock. Many of these advocacy groups have been asking for a public hearing since January. They've been seeking a public hearing on the air application down in this county, whether it be in the previous air applications which were withdrawn or the new application that was filed since January. Some of them even put curriculum vitae, resumes for expert witnesses in their public comment letters that they submitted in public comment to the department. So I think that many of the parties here today are advocating for delay. The rules caution against undue delay. There is a statutory period that we must follow for the processing of this application, and we need to follow the rules and procedures that are in place. And I think the department is fully capable of doing that within the time frames prescribed. Thank you.
Mr. Vigil, do you have any response to this?
Thank you, Mr. Hearing Officer. From the department's perspective, I think Yucca's legal analysis is correct, but with regard to a position on it, the department, I think our position is we're sort of stuck in between. We have parties that want to delay the hearing. We have a party that wants to have a hearing as soon as possible. And the department, we incur legal liability either way. We're sort of in a between a rock and a hard place, and not complaining at all, but to that end, really our position is that we should, to the extent possible, adhere to the statutory deadlines. That's our best defense. Everything else is sort of, I don't know. We have to take those arguments as they come, but I'll just close by saying I think Yucca's legal analysis is correct, and it is not. I understand that the statutes are vague in some regard, but they have to be read, of course, in conjunction with the rules, and it's pretty clear that the secretary can really only give a 90-day extension because it's a due process protection for the applicant. And I think that's all for now. Thank you.
Okay. Well,
Mr. Shepherd, could I reply to that very briefly?
No, excuse me. Let me finish my thought here. Certainly, I hear what the parties who are opposing this proposed schedule. I hear what you're saying. On the other hand, with all litigation, in a case like this, this case has been pending for a long time. You know what some of the basic issues are, and some preparedness has had to have been done. If not, you really were not representing your interests very well if you're not already doing some work in anticipation of an upcoming hearing date. On the other hand, is there a little bit of movement here? I mean, could we extend it for 30 days? Would there be any particular prejudice to Yucca growth infrastructures if we extended this hearing date for, say, 30 days, give the parties that much more time to prepare?
Yes, Mr. Hearing Examiner, we think there would be extreme prejudice in this event for a couple of different reasons. First, there are post-hearing timelines that are set out in the regulations. And so really we are bumping up against that November 23rd timeline by holding the hearing in August. And so by holding the hearing when it's set for in August, there's not much buffer on the back end, given the regulatory submissions that need to be made. There needs to be written finding of facts and conclusions of law, the hearing officer's report. Everybody needs to review the record, and all of those have prescribed timelines associated with them. We have proposed some timelines there, but really it all kicks off from the hearing. And so there is an extreme risk that we will not make the November deadline unless we hold the hearing in August when NMAD is ready, the applicant is ready. All of these opponents have been at the table since January, anticipating this hearing, advocating against this hearing, or asking for this hearing. They've actually all been advocating to have this hearing, but advocating against the project. The other issue is that the applicant has spent an extreme amount of money and cost in preparation for this facility for this project in southern Diana County. And so it would be extremely prejudicial to the county and its tax revenues, to the people who are employed. There's already over 400 New Mexicans working down at this site. If we are not able to get certainty to make sure that that employment can continue and that more and more New Mexicans can get jobs down there, as you said, this portion of the county deserves an answer. And the first $50 million from this project go to investment in improving the water infrastructure. And we know that the water infrastructure down there has had problems resulting in high arsenic levels and poisoning residents. This project provides a lot of benefits to the community, and the community needs to know whether or not those benefits are going to materialize and move forward.
Okay, thank you.
Mr. Hearing Officer?
Yes.
Councillor Vihil brought up the issue of the ability of the secretary to extend 90 days in this process, and that is something that he's entitled to do. Given, I don't think the public deserves to have something jammed down their throat basically because of a time constraint, and especially people who have raised legitimate concerns. And why not ask Secretary through council if he will exercise that action so that we can extend this timeline. If I understand you're trying to be fair to both parties here, but what has been proposed so far is eminently unfair to the general public, and there's already great distrust. This is reminiscent of a matter before a sister agency in which the department was pushing something to get it over the finish line just barely a year ago. And the public was outraged over it. You don't have to take my word for it. You can go anywhere and read about how upset they were and how people covering those issues felt that the public was getting railroaded on it. Whether they were or not, that was a perception. And it seems to me that the department has the ability to extend this, and they ought to. To ask people to all of a sudden come up in less than 2 weeks' time and in 2 days' time to present dispositive motions is ridiculous. But I'll end with that. Thank you, Mr. Hearing Officer.
Good, thank you. All right, well, I'm going to have to do actually a little research before I make a final determination on this. But I do want to indicate to you all that some of the suggestions that Ms. Bradford has included in her proposed scheduling order, particularly those in paragraph 4 of her order, and some of them in paragraphs 5 and 6, which I wish I could share with you, but don't seem to be able to. I seem to be extremely, I seem to be very good proposals, and I would intend to incorporate those into an order that I do enter here. Those proposals have to do with, for example, the first day of the hearing, setting that day aside for public comment. It seems to be the way I read this suggestion in paragraph 4, that instead of trying to have public comment at 1 o'clock every day of the hearing or 5 o'clock every day of the hearing, just have one day, the first day of the hearing, dedicated to public comment. I don't think 1 minute per person is adequate. I think it would have to be 3 minutes. And then paragraph 5 of the suggestion is that again, as Ms. Bradford had discussed earlier, kind of grouping together parties who have this common interest and having them sort of presented as a group instead of just each individual making the same argument. I think that certainly is a good idea. It certainly expedites the hearing.
Hearing officer, can I discuss that point briefly?
Yeah, go ahead. Go ahead.
I think forcing the parties to confer is not and present together is not reasonable. I mean, many of us are attorneys and advocates who are representing our clients, and it would put us in a very strange position if I had to do something with other parties against my client's wishes. I mean, that creates kind of fiduciary and professional responsibility issues. It's true that many of us on this call are opposed to the huge amount of pollution coming out of this and want a fair and impartial hearing. But that broad umbrella is, I think, not enough to lump us all together. There are many different viewpoints on this, and some of our arguments will be similar. You're certainly entitled to kind of limit certain things to prevent duplication. But putting us all in one group and then limiting cross-examination to 45 minutes for that entire group when there are, 5 or 6 people on this call so far and others likely to join, that's just not really giving a fair shake to the parties. And it's potentially putting us in difficult positions with our clients.
Yes, thank you, Ms. Cox. I appreciate that. I believe that this procedure, although it's been suggested here by Ms. Bradford, has also been advocated or used at different times by Felicia when she's been a hearing examiner. And I think that she's used it pretty effectively in large hearings like this. And so I think that it makes sense, and I think that if there were circumstances that would mean that sort of the collective presentation due to specific differences might not work, I think those would be entertained in the course of the hearing. But I think the goal would be to try to have collective presentations to the extent possible. It may not always be possible, but to the extent possible, I think that's an effective way to try to move through a hearing like this.
I'm not sure that the rules would permit that, Mr. Hearing Officer. Maybe we need to get the rules up. I think the parties have the right to present their own cases. And I have the rules open, and while you all are chatting, I want to make sure, because it does seem a little unorthodox to do that, and it's not in the department's interest to have this overturned on appeal. So I want to make sure that that we have give the parties every opportunity to present their case. So I'm going to shut up here while you guys are talking. I'm going to review the rules so that we have some kind of black letter basis for this. So I'm speaking out of school now, but I'll be checking while you continue the discussion. Thank you.
Mr. Hearing Officer, I do believe that this is highly unorthodox. We all have been in a very recent, very long-term hearing with hearing officer, or if she never did that. Of course, we will coordinate to the extent possible. We don't want to have duplicate information. However, under Albuquerque Bernalillo County Water Utility Authority versus New Mexico Public Regulation Commission, 2010 New Mexico Supreme Court case 013, it is well settled. This is from the New Mexico Supreme Court. It is well settled that fundamental requirements of due process in an administrative context are reasonable notice and an opportunity to be heard and present any claim or defense. And so we have a right, each one of us who are interested parties have a right to present a claim or defense to this proposal. And I just would like to reiterate that it would be highly prejudicial to, first of all, require us to present the same evidence and also present it in 2 days. We have come to a reasonable suggestion of starting the hearing in October or November. We're asking for Yucca, but more importantly for you to accommodate us. We were
Excuse me. Now, you're drifting away from the issue that we're really discussing at this point, whether the idea of collective presentation
Okay, so I'll just
works or not. Now, Felicia suggested to me that it might work. I have not used that process in the past. I kind of was admittedly relying on her experience as a hearing officer in these sort of cases. And it seemed like that might be a possibility of a way to move forward. I'm hearing from what Mr. Vito is suggesting that may be not only not the best way, but also may encounter some due process violations. So I'm willing to accept that at this point and not include that idea in the scheduling order. So just to give you that.
Mr. Hearing Examiner, the rule where I got the idea from is NMAC 20.1.4.400. It is B2, examination of witnesses. And the third sentence states the hearing officer may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. And so that's the authority. Felicia may have some suggestions of what has worked in some of the hearings in the past, but that is the authority that's laid out from the rules.
But that would require a finding. So I think a prospective limitation may not be permitted. In other words, it seems like you would have to make some kind of factual finding. Stop harassing a witness. Hey, we already heard this before. I'm no fan of big long hearings, but I think that what I'm hearing from that is that there has to be some kind of finding on the base, undue repetition, or the third. There was what was the last one? That was the one that was the most broad, but kind of a undue use of time or something like that. But again, even then, there would have to be some kind of finding, it would seem.
Yeah, I hear you, Mr. Vito. Ms. Bradford, I would say that it's a very broad interpretation of that particular rule. Creative, but a little bit broad. So I think that idea will not be included in the scheduling order that I'm going to prepare. So so we don't, I'm going to have to look at a couple of issues. I'm going to have to look at this November deadline. I want to see to what extent we can extend the hearing date a little bit to give all the parties a chance to prepare. And I'm not ready to do that without doing a little bit of independent research on my own. I will do that very quickly and get this out. I wouldn't anticipate really and extending the start date by more than a month or 6 weeks or something like that. I do, not pushing this until April, not pushing it into November. And unfortunately, but that's what I feel I have to do before I'm comfortable with submitting a scheduling order at this point. I know that leaves you all hanging, but I will not leave you hanging more than just a few days.
My understanding is that the draft permit will be released. I mean, it's imminent, and the public notice will be published, I believe, Friday. So that will give everyone a more basis, probably not to agree, but at least you'll have much more information about what you will need to do to prepare for the hearing. So that's all coming. It's imminent, this week.
Okay, good. Well, then let's, today's Wednesday. By Monday, I will have the scheduling order prepared and ready to be distributed for your information. Is there anything else we need to do? I mean, there are lots of things we could talk about, but I think we've gotten the essential things that we need to get done here today. At least we've gotten a way to proceed to get them done, in my mind.
We have one last thing, Mr. Shepherd, a small thing. I would encourage having more than one day of public comment. It wouldn't have to be the whole day, but one of the reasons at a lot of other hearings that they have multiple public comment sessions scattered throughout is to accommodate people's schedules, and especially because then they can get in line at different times. So I just encourage more than a single opportunity, even if that's a long opportunity. I think there should be more than one opportunity for public comments. Thank you.
I agree, Ms. Scott, and I think the problem with a case like this is you don't know really what's going to happen. You don't know how many people are going to show up. You don't know how many people are going to make public comments. You can say, okay, we're going to have one day of public comments, and then you might have 300 people who want to make a comment. And, they all have the right to make a public comment. And so a one-day rule simply would have to be modified to accommodate the needs of all the people who have a right to make a comment. So, that you have to. I think we can start with a one day, but realize that put some language in there. One day, if adequate. If not adequate, we'll have to have more time for public comment at the hearing. Yeah.
Hearing Officer Shepherd, Marilyn asked again. We would like to ask you to include the right for discovery. There's very technical issues here, and we would like to, and it's completely up to you to order that or not. That was in our suggested order, and there's some issues that are extremely technical, like the questions that I raised earlier about the sufficiency of testing. And so we need to know that so our expert can opine about that. And to not be able to determine that in advance would prejudice us and would prolong the hearing. So we're asking, Your Honor, to consider to allow discovery for at least technical matters.
I hear you, but I'm not going to issue a blanket discovery order. I think that what is it, 200.1.4.200E handles discovery appropriately, and I think that is a good rule, because that will, not that anyone here would want to do it, but it will prevent the abuse of the discovery process, which a blanket discovery order might create. And so it will have to be a case-by-case request for discovery.
So would that mean that
there's also IPRA. So, I mean, again, even today, to the extent that you know what documents, and I understand it might take time, but IPRA is available. All these documents are, available. To the extent you identify what you want, you can submit an IPRA request. And, IPRA is very broad. It's very, very, I mean, it's very broad. You could pretty much get whatever you want under IPRA.
Your Honor, first of all, IPRA has been not followed by the Environment Department or the agencies repeatedly. So that's one of the big basic problems. But the other thing is that some of this has to do with yucca and what yucca infrastructure, what actual testing that they have done. So all I'm asking is for a procedure. Do tender the discovery request to you and then you
Yes.
approve them? Okay.
Yes.
So how could, if you could anticipate, thank you, first of all, and if you could anticipate the procedure that should be followed for that discovery, we would, I mean, speaking for New Energy Economy, we would like to get that out as soon as possible and get your approval on that to both NMED and Yucca Infrastructure, because there's some very technical issues that that our experts are going to need to know.
Mr. Hearing Examiner, if I may ask a question, and this is a procedural question that I had when looking at the regs, and I raised it in my response. 20.1.4 200E has a subtitle, and it says Special Procedures for Hearings under the Solid Waste Act. So it appears to apply to special proceedings for hearings under the Solid Waste Act. And that is not this proceeding here. I could not find another discovery rule under the rules. And so I just raised that. Yeah.
I don't either. I don't see, I've read through the rules a couple of times, and I don't see any other discovery rule other than this one that refers to special proceedings under the Solid Waste Act. But this seems to be a reasonable way to proceed with discovery, unless you're just going to say there are no limits to discovery requests, and we can all be swamped with discovery requests, and that can be used as a trial tactic, as you all know, and that's to be avoided. I think that these rules really seem to be pretty reasonable. The problem is that they may not specifically apply to anything other than the Solid Waste Act, but to the extent that I have the authority to do that, I would incorporate these rules into the discovery procedure in this case, and the procedure would be file request for discovery. And, you know, and we look through A, B, C, and probably get a response from the party upon whom a discovery request is made, and a ruling about whether or not you get discovery.
Yeah, and we would.
Thank you, Your Honor.
It's a little cumbersome, but I think it will achieve what we want, which is a discovery process that can't be abused.
Yeah. And we agree. We don't want a discovery process that could be abused. I would like to preserve the ability to raise an objection that discovery is allowable, because I don't see the EIB addressing it here. That is something that I have not had a proper opportunity to research in full disclosure. Yeah.
Well, it seems to me in a case like this, the discovery has to be allowed. I mean, just kind of common sense is going to tell you. I know you have your technical testimony, you filed that, and that's pretty inclusive. Rebuttal technical testimony is very inclusive and should lay out everything that your witness is going to testify to. But nonetheless, there's got to be some questions that the opposing party is going to have that could only be addressed by a discovery request. I mean, yes, you can preserve your objection to discovery is preserved, and we may go to hearing. I may allow discovery. Discovery will have happened. We will have a hearing. We'll have a conclusion. We'll have a decision, and then you can file an appeal and say, "Oh, all that discovery was wrong, and therefore the whole opinion by the secretary should be undone because there was a procedural error on discovery." I mean, that would be the way it would run, actually. And that doesn't seem to make any sense to me. So at this point, I'm going to say, yes, we have discovery that's going to basically follow the procedure that we've just discussed.
Okay.
Okay. I mean, you don't have to agree, but I have to say, okay, that's what we're doing. Okay. Well, thank you all. And
Mr. Hearing Officer,
Yes, go ahead.
just one question. First of all, Bruce Weatherby, thank you for what you just said. I think it's important. And I'm trying to find out, I'm assuming that this is part of the record or it's stored someplace. Is that, would Mr. Vihil or someone that's running this understand? This hearing, this.
Yes, Mr. Willoughby, this hearing has been recorded.
Okay, thank you.
And Mr. Lopez, that's correct, right? This hearing has been recorded. It is.
Yes, sir.
Yeah, it is
Okay.
part of the record at this point.
Yes, sir.
And thank you very much, and thank you for your service.
Yeah. Okay. Then thank you all.
Thank you.
Mr. Hearing Officer, this is Chris Vihil, Environment Department. One last question. Is it possible that we could have, once the scheduling order's out, because I'm a little unclear, can we get a procedural order and have maybe another conference that would hammer out, because I'm a little unclear about how the hearing's going to proceed. Maybe I'm alone in that, but it seems like that either we do that now or have another conference. Of course, maybe I missed something, but just so the parties understand, the order. I know that the petitioner is going to go, or then the department's going to go, but it might be beneficial for the opposing parties to know in what order they're going to appear in, because they may fly in witnesses. I'm not sure. It's something that happens. So having some clarity about that might be helpful. And if that's already been done and I missed it, dealing with
we have not spoken about that specifically, Mr. Vihil, but the rule 20.1.4 it does have set out a pretty specific way that the hearing is to be conducted. The sequence of presentation and cross-examination and technical evidence and then non-technical evidence and the right to cross-examine, that seems to be pretty specific, and that is,
okay.
I'm assuming the way these cases are always handled, and I'm certainly assuming that's the way I intend to handle this case.
Okay.
And the rule seems, relatively clear.
Okay, excellent. I also have another proposal, and I'm not sure how everyone feels about it, but it may be helpful, for example, and it may expedite the hearing if, for example, the department and the parties present their witness, gives the direct and rebuttal at the same time, and then that our witnesses are cross-examined as a panel. That seems to have saved time in the past, particularly with the department, because everything we do is with teams, or at least have that option. That way, when attorneys are cross-examining, they don't run into someone that says, "Oh, I didn't do that. That's Frank," or "That's Joan," or whatever. That way, the whole team is there, and whatever answer that the opposing parties or the cross-examiner is looking for, then they can get that answer without having to switch out witnesses and that kind of thing. And that's something that Felicia would frequently do. Is that something that you and the other parties are open to, at least the option?
I am certainly open to that. Yes. Certainly open to that.
I believe that the applicant is open to that as well. We definitely are interested in finding ways to make the hearing make sense as we put on witnesses and have cross-examination.
And maybe make it an option, maybe an option as opposed to a requirement if a party would prefer to, not do that, or if they only have one witness or whatever.
Oh, when we get to that point in the hearing, I'll raise that and we'll make a ruling on it.
Okay, thank you.
But to me, it sounds like it makes good sense. Because the worst thing is to have the key witness not understand at the time when you're asking everybody else what's going on. So, and do the parties generally in these cases try to determine the admissibility of exhibits prior to hearings, or do you wait until the last minute and rule just, exhibit by exhibit by exhibit as they're tendered in the course of a hearing.
I've seen it done both ways. Typically, if we have problems with exhibits, we might file a motion in limine. It's my preference that we admit everything in bulk, but I've seen it done both ways.
Okay. Well, if we, as we get closer to it, if we can do that, that might also expedite the hearing. If we don't have to deal with each issue one at a time as they're being tendered. But we can decide that when we get there, I think. Anything else? Okay, we're done. Thank you all.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you.